Welcome to the Delaware SBDC interview series, Considering Throwing in the Towel, Reflections for Small Businesses. If your business was adversely impacted and you are considering your options, this series of interviews will provide you with valuable information. In the second interview, we speak with Charles Shurr about legal topics such as state laws, bankruptcy and insolvency, and lender and landlord relations.
Thank you for joining us for video 2 of our interview series. My name is Anthony George. I'm a business advisor at the Delaware Small Business Development Center. At the SBDC, we deliver training and free professional consulting services to help startups and existing small businesses formulate and execute strategies to grow and succeed. I'm developing this interview series to provide practical advice to small businesses adversely affected by the COVID-19 pandemic. I'm happy to introduce today's expert, Chuck Shurr. Chuck is an attorney with Kozloff Stout, where his practice focuses on banking and creditors' rights, bankruptcy, and general business and commercial law. He's a former commercial banker and a graduate of Widener University School of Law here in Delaware. Thank you for joining us, Chuck.
Thank you. It's great to be here.
I want to start with our first question. Can you please touch on some recent federal and state legislation that might be able to be leveraged to assist small businesses impacted by the pandemic?
Sure. Most of the federal and state laws that have been passed have really focused on individuals. And where I'm speaking about there is the foreclosure, moratoriums on foreclosures and evictions. It really, those efforts, the governmental efforts really have not been focused on small businesses with respect to eviction and foreclosures. What efforts have been made at the governmental level towards small businesses has really been focused on providing financing for small businesses to help through the pandemic. It's been in the form of the PPP loans through the SBA, the EIDL loan program for grants as well as loans. And there's also been, that's on the federal level, then on the state level, there have also been some loan and grant programs that have been available as well. So those have really been the governmental efforts focused on small businesses. There have also been some laws that have been passed at the federal level with regard to employment, employees being able to take leave during this time for childcare or for other reasons. But those again are not really geared towards, I'm going to say, assisting the small business through the pandemic. It's really been focused more on the individuals instead of companies.
Okay, thank you. So can you please discuss the benefits that an individual who filed a former LLC or corporation or a corporate entity might expect to have in a distressed situation as compared to an individual that's operating as sole proprietorship?
Sure. An individual who forms a business entity, whether it is a limited liability company or a limited partnership or a corporation, would be able to enjoy some or all, depending on the situation, insulation from personal liability for debts and obligations of the business. And those obligations can come in a variety of forms. It can be outright indebtedness owed by the business. It could be product liability obligations. It could be rental obligations. However, we have to be a little careful when we're talking about a lot of small businesses because many small businesses, in order to obtain financing from a bank or obtain space from a landlord, are required to personally guarantee those obligations. So that means that although the company has been set up and may have provide that formation of that entity provides personal liability protection, many times the individuals have agreed to be personally obligated for the debt anyway. So again, it can provide some personal liability protection for certain things, but in many cases we see small business owners are personally obligated because they were required to be personally obligated in exchange for obtaining the financing or obtaining the space to operate their business.
Okay. Can you please discuss the importance of a business developing a financial snapshot?
Well, I think it's very important for a small business owner to have a good picture of their financial position, understanding what level of assets they have, what level of liabilities they have, their revenue level, their expense level, and I think it's critical that the small business owner work closely with their accounting professionals in understanding that important decisions have to be made based on the financial position of the company. In order to make those decisions, a small business owner has to understand what the financial condition of the company is.
Okay, thank you. Can you touch on some common leverage that small businesses have, whether secured, unsecured, different types of leverage that an average small business would have, and some recourse that those lenders may have over the small business owner, and also vice versa? What are some leverage a small business owner may have over the lenders?
Yeah, I guess let's talk about the different types of, loans and lenders that a small business may have. A small business owner or a small business can have loans, for example, from banks, financial institutions. Oftentimes, those loans, whether a line of credit or a term loan, as we mentioned, are oftentimes guaranteed by the business owner, so that not only is the business itself obligated to pay the debt, but also the individual is obligated to pay the debt. And a lot of times those business loans are then secured on the business assets. The loans have a lien on the business assets. It's like having a mortgage on your house. It's that asset, whether it's equipment or inventory or real estate, is there to back up repayment of the loan. So if the loan isn't paid, the secured lender would have recourse and be able to pursue those assets and liquidate those assets in order to repay the debt. So that's one type of debt, but there's other types of debt that a business can have as well. A business might just have equipment financing or a vehicle loan, and many times those types of obligations would be secured just by that particular item, and those loans may or may not be guaranteed by the small business owner. Sometimes we see that, sometimes it's not. So that's another type of financing that small businesses have. And then going down the list, there could be unsecured creditors. And one example would be if the company has a company credit card or an unsecured line of credit with a bank or financial organization. That's an unsecured. Another type of unsecured credit, it would be what we call trade credit. Would be if it buys inventory from a vendor and is obligated to pay for that material. Typically, that vendor that sells those items to the small business doesn't take any kind of lien or anything. It's essentially an unsecured loan that's made, or unsecured credit that's made available to the small business owner. So those are the different types of debts. One thing I did want to mention, and something that we've been seeing a lot, unfortunately lately, is from time to time that there are companies that have really popped up over the last several years and are lending to small businesses at um, very high interest rates or involving a lot of fees. They're oftentimes agreeing to give a chunk of money up front, and then the business has to repay it based on their credit card receipts. They have to channel some of their credit card receipts directly to the lender, or the lender charges their account, sometimes on a weekly basis. But those are all very high interest rate, high fee type of financing that's available. It can be, I think, very problematic for small business owners to get that type of financing. It's oftentimes marketed towards perhaps companies that are struggling and are not doing well. And it sounds great because the business owner needs the cash, but it could really spell disaster down the road because of the costs that are associated with the financing. So it's just something to be aware of. I see solicitations. I see businesses getting solicitations for those. I just be careful. I just encourage business owners to be careful about that kind of financing and really understand what the true cost is of that money.
Okay, thank you. Many of our of our clients or small businesses in general will lease space. So can you talk about the landlord-client relationship and when a company might be in distress, some leverage that a landlord has over their client, and then vice versa?
Sure. Again, a lot of times landlords, certainly with if it's a strip center or a mall or a large commercial complex, a business park, something like that, a lot of times the landlord will require the small business owner to personally guarantee that obligation. So a lot of times you're not, a business owner is not going to have insulation from personal liability for unpaid rent. And one of the things to be aware of in some jurisdictions, Pennsylvania happens to be one of them, not sure about Delaware, but some jurisdictions do not require a commercial landlord to mitigate its damages or to re-rent the property if the tenant moves out, doesn't pay the rent, etc. So the small business owner that personally guaranteed the debt could be responsible for all of the rent payment over, say, a 5-year lease, even though maybe it was only there for 2 years and it had to close up. Well, the company, and if the individual guaranteed it, they may be responsible for the full 5 years worth of rental payments. And again, depending on the jurisdiction, the landlord may not have to even try to re-rent it for those last 3 years. And again, that varies by jurisdiction, and it can also vary by contract. Those are terms to be aware of when the small business owner is entering into a lease. Sometimes those things can be negotiated, but it's certainly something to be aware of. But one of the things I think that's important to keep in mind if we're talking about either a landlord or a business, business creditor, a bank, trade creditor, whatever, is if the small business owner is having difficulty in keeping up with its obligations, in paying the rent, in paying the loan payments, in paying a vendor for inventory that it purchased, I think it can be very important for a small business owner to be very proactive and communicate with the landlord, with the bank, with the trade creditor, and let them know, hey, we're having this difficulty. This is why. This is what we plan to do about it. This is the time frame. I can't pay everything now, but I need 30 days. I need 60 days. I need 90. Something. That providing some sort of plan to the other party that they're going to be able to get caught up and honor their obligations. And I know that can be, especially now, exceedingly difficult because of the great amount of uncertainty that's out there. So I know that that can be a very challenging thing to do. However, maybe one way of dealing with that is trying to keep a plan, short term. If you can't commit to 6 months or 3 months, maybe you can at least commit to doing something over the next 30 days, or maybe over the next 2 weeks, something along those lines. And then, keeping those, keeping those promises. If you say you're going to pay them, $1,000 this week, pay them $1,000 this week. So you want to only commit and agree to do the things that you're, reasonably sure you're going to be able to do. It's just important in maintaining those relationships going forward, and trying to work through these situations. And maybe this would be a good time too to talk about whether you want to talk to an attorney or not about it, and that's entirely up to the business owners. Some business owners are comfortable with dealing with that. Some business owners are not, and maybe it depends on the amount of money that's at stake as well. So maybe if we're talking about $10,000, it's not as maybe the business owner feels comfortable discussing those kinds of arrangements. Maybe if we're talking 100,000 or $1 million, it's maybe not so. Maybe they're not so comfortable doing that.
Okay, thank you. I know we touched on personal guarantees a lot in the past couple questions. Can you talk a little bit more on any type of personal leverage that a business owner may have over a personal guarantee and what he or she could expect?
Yeah, good question. Even though a person has personally guaranteed a debt, there may be some protections for that person. And again, if you personally guarantee an obligation, that means that you're personally responsible for it. That means that a creditor could sue you for that debt, get a judgment, and then pursue your assets for repayment of that judgment and that debt. So that's really what we're talking about. But there are certain assets that a person typically owns that may not be available to satisfy that kind of judgment. For example, if the business owner has personally guaranteed the debt, however, their assets they own jointly with their wife or husband, that those personal assets may not be available to satisfy that judgment. So the creditor could get a judgment, and if everything's owned jointly, if they only have a judgment against the individual, but the individual owns everything jointly with their spouse, maybe those assets aren't available. And then the other thing is their retirement plans, 401k, IRAs. In most cases, now there are exceptions, but in most cases, they're going to be typically insulated from availability to pay debts. So they won't be attached by a creditor. And then there's also bankruptcy, and that's where I was talking about with the retirement plans. Typically, retirement plans are also protected in bankruptcy. For the most part, there have been some, if there were transfers into it, some other changes, perhaps they might be subject or vulnerable to attack. But typically, even in bankruptcy, retirement plans are going to be insulated. And bankruptcy, of course, would be an option as well for an individual in the event they are unable to pay their debts and obligations. That's something that an individual could look at pursuing.
Okay, bridging off the bankruptcy topic, I know there's a lot of misconception around small business bankruptcy right now. So can you just give us an overview and dive into some risks and misconceptions that maybe a small business owner might not be thinking about?
Sure. Well, generally speaking, there are, we're talking about three main types of bankruptcies. There's a Chapter 7, Chapter 7 liquidation bankruptcy, and that's typically available to just about anybody, individuals as well as businesses. And in that scenario, under a Chapter 7, typically, if it's a business filing Chapter 7 bankruptcy, that the business would basically be closed down, the assets would be liquidated and used to pay the debts of the debtor, the company. And again, and if it's an individual, again, after certain exemptions are taken, if there's any assets left over, which many times there aren't, if there are, then those assets will be liquidated and used to pay creditors. So that's Chapter 7. That's probably the one, that's sort of a straight bankruptcy. That's sort of the easiest, simplest bankruptcy, if you will. The next kind of bankruptcy is talk about as a Chapter 13 bankruptcy. You may have heard of. That is available typically only to individuals. However, it could also be available in the event the small business owner is operating as a proprietorship. So proprietorship is typically not recognized as a separate and distinct legal entity from the owners, from the individuals. So sometimes a small business owner, if it needs to reorganize and it's operating as a proprietorship, could file a Chapter 13 bankruptcy. Now there's debt limits on that. You can't exceed certain amounts. It's called typically an individual reorganization. And typically it's for someone that has sort of regular income. Maybe they want to try to keep their house, keep their car, keep certain assets, and repay those debts over time. Sometimes there's tax, federal or state taxes. That's another, typically large liability we see sometimes in bankruptcy are unpaid taxes. And then the third type of bankruptcy to talk about would be Chapter 11 bankruptcy. And a Chapter 11 is typically available to small businesses or any type of business. There's some certain specific provisions related to small businesses now. But just as a side note, Chapter 11s would also be used for individuals that have very large amounts of debt. Chapter 13 has you can't exceed certain debt limits. Chapter 11 we see used by individuals if there's a lot, exceed certain levels of debts. And we're talking millions of dollars there, so it's pretty significant. But in Chapter 11 for a business, there have been some changes that are designed to lower the cost and make it a little easier for small businesses to reorganize in bankruptcy. One of the criticisms of Chapter 11 over the years has just been the complexity and the cost that's associated with navigating a business through Chapter 11. And it's really, unfortunately, resulted in a lot of businesses simply being unable to avail themselves of a Chapter 11 or bankruptcy reorganization. They just can't afford it. So there have been some changes to the bankruptcy code to make some provisions of Chapter 11 more small business friendly, if you will. I think it sort of remains to be seen, how much benefit those changes have, and a lot of them are pretty new. There were some small business provisions in the bankruptcy code for many years that I think provided sort of limited relief, but more recently they've made some additional changes in an effort to, again, benefit small businesses. But one of the things, I think there's a lot of, as you mentioned, there's sort of a lot of misperceptions about bankruptcy. And while, the stigma of bankruptcy or whatever may not be may not be what it used to, if you will, there's still, misunderstanding of what you can really accomplish in bankruptcy. And this is where, our earlier discussion about, the types of loans and the types of lenders you're dealing with, play an important role. For example, if you have a lot of secured debt, or if you have secured debt and you file bankruptcy, the secured creditor is, given sort of a lot better. There's a lot better provisions in the bankruptcy code for secured creditors than there would be for unsecured creditors. And if it's a secured creditor, typically the secured creditor is going to be entitled to be paid the value of the asset that it has as collateral. So if a small business owner has equipment and inventory that's worth $100,000, and it owes the bank, say, $50,000, it's going, the business owner is going to end up having to pay in full the bank for the value of those assets. It's not, some people think that, oh, I'll file bankruptcy and I'll just get out of my obligations. That's not really the case in a lot of situations, especially when you're dealing with secured creditors. And that's not just equipment and inventory. That would also apply to real estate or other things that might secure the debt. When you're dealing with unsecured, that's where you typically have, potentially some more benefit in bankruptcy. That's, if you have a lot of, say, credit card debt, if you have a lot of trade credit that's owed to, other companies or inventory or what have you, or services that were provided, that, those, a lot of times unsecured debt, it does not get paid through bankruptcy. So that is a potential benefit. What we see in a lot of cases is, that can have an effect, though, on the small business owner's ability to continue to operate in the industry if it, hasn't, satisfied its obligations to other, sometimes very, key companies, providers in their industry. So something to keep in mind. Yes, you can, you may be able to get out of paying for certain types of debts in bankruptcy. Sort of understand the implications of all that, and also understand that it's not going to apply to every kind of debt.
Okay, thank you. I know you mentioned engaging with counsel during part of this process when you're negotiating with lenders, communicating with lenders, depending on the size. Can you talk about how a small business owner can go out and find quality legal counsel?
Sure. And that's, it's important for a small business owner to have, good, competent legal counsel familiar with, business laws and transaction work, employment issues, litigation, etc. And if a small business owner does not already have counsel that it's comfortable with, many times a small business owner may be able to get recommendation from its accountant, maybe from its banker, maybe from another small business owner. Hey, who are you working with? A lot of times we see, sort of those personal recommendations. And the other thing is, but if you can't, typically every county has a bar association that would, should be able to provide a referral to an attorney in that area that would be able to assist the small business owner with regard to the types of issues that it needs assistance with.
Okay, great.
You're welcome.
So this concludes our interview for today. I want to thank you for watching video 2 of our interview series. You can learn more about the Delaware SBDC at delawaresbdc.org. And our expert, Chuck Shurr, you can learn more about him at kozloffstout.com. That's KOZLOFFSTOUDT.com. So thank you again for joining us today. And this There will be one more interview in this series where we'll talk more about human resources in a distressed company, which will be posted shortly. Thank you.
Thank you, Anthony.
Thank you for watching. The Delaware SBDC provides one-on-one free and confidential business advising. Contact us and schedule a meeting today.